Right. Good morning, everyone. Thank you for attending Boardman Clark's overview on the new Wisconsin Limited Liability Company law. This presentation is being recorded, so I'll give some brief background on Boardman Clark and then the speakers. Boardman Clark is one of Madison's largest and oldest law firms. While we're based in Madison, we do have offices throughout South Central Wisconsin, and we service clients throughout the state and beyond. I'm Jeff Stork. I'm the chair of the business practice group. I'm based in our Baraboo office. I work with many closely held businesses and liability companies, or LLCs. I'm also the lead author of the Wisconsin Data Trace Treaties on Wisconsin Limited Liability Forms. I'm going to let my associate Rob introduce himself shortly, but first I want to give an overview of today's presentation. Focus is going to be on changes on the Wisconsin's Limited Liability Company LLC law, Chapter 183, and steps that LLCs should consider taking now and in the future. Be aware that there is a deadline of December 31st, 2022, which is coming up quickly for those that want to opt in to the old law and not be covered by the new law. But much of this presentation will be relevant even after the start of the year. We've given this presentation to accountants in the past. We're giving it to attorneys today, so we may be focusing on some more esoteric issues. However, we're not going to be spending a lot of time on the history of the LLC law. We're also not going to be spending much time on the changes to Chapter 178, which affected Wisconsin's limited partnership law. That was part of the same law. We'll touch on that a little bit, along with some of the corresponding changes to other sections of the law. But if you have questions about the limited partnership law, we can either address that separately, or we do have some articles on our website, boardmanclark.com, boardmanclark.com, under our business minute. So Rob's going to do the main presentation, and I'll provide some commentary. We'll try to address questions during the presentations as they come up. However, we've reserved time at the end for questions. And we're happy to answer questions after that, after the presentation. We can also make copies of the PowerPoint available. With that, I'm going to turn it over to Rob.
Hello, I'm Rob Hammeister, and as Jeff said, I am an attorney here in Baraboo, and I also am a member of the business practice group. So we're going to hop right in because Jeff laid the groundwork for this. But the reason we're here is that basically in April, Governor Evers signed a bill that overhauled Chapter 183 in its entirety. And so outside of just the change to the law, the other thing that's takes a little getting used to is nothing has the same number as it used to. So you can't run a red line and see the differences. There's not a lot of common language in a lot of the sections.
And we ran into that already internally, and we may cover it a little more, but there's a section in the old law under books and records that is not only totally renumbered, but it doesn't have the word records in the title. So if you search for records, you aren't going to find the new statute addressing what records an LLC must keep.
Yeah, and so because of that, the recreation of the chapter, I've been finding that every time I hop into it, I either find something that I thought was no longer in it, or was moved, or is kind of new altogether. So it's kind of evergreen every time we go into it.
And a practical point, if you go to the internet on the state statute site, they have the new law in effect. December 1st, 2023 is already posted. So you have to search to find the current law that's still in effect till year end. And so if you go just Google trying to find Chapter 183, make sure you've got the right version.
And then Jeff also touched on the fact that in addition to recreating Chapter 183, there were changes to Chapter 179, Chapter 181, 180, and 178. So some with business corporations and things like that, and other business entities, a lot of the changes that were not as drastic as limited liability companies, but were more so to make a seamless transition for cross-species mergers or
and you can convert cross species. So Chapter 180 is the for-profit stock corporation. Chapter 181 covers non-stock, non-profit corporations. 178 is general partnerships. 179 is limited partnerships. 183 is LLCs. basically you can flip flop convert anything through that in Wisconsin. You can also convert from Wisconsin to other entities, and the changes kind of harmonize the language used for that.
So when does the new law go into effect? Generally, it applies to every LLC beginning January 1st, and then all LLCs formed after the beginning of the year. And so if you're currently, if an LLC currently exists, it can opt out by filing a statement of non-applicability. It's a simple form. It's a similar form for 179 and for 183. And there's no filing fee. You basically put on the name of the LLC, some other information, and basically say, I'm opting out. And you will then continue to be governed by the law as it exists today.
And again, it's a very simple form. Your clients could probably do it. One thing that is a little confusing, it's the same form for both LLCs and LLP, limited partnerships. So it's got two form numbers. It's the same form. And there's just very little information needed. But if your clients file on their own, you want to make sure you get a copy from them of the confirmation it was filed.
Yep. And then the other thing is one of the errors that we've been hearing back is clients forgetting to put the name of the LLC on the form. And so making sure that it is filled out properly. And then even though the form doesn't say so, it can be emailed to the Department of Financial Institutions. So it doesn't only have to be mailed in, it can be emailed. But the important thing there is December 31st as the deadline to get that filed with DFI. Alternatively, an LLC may opt in early since we're already in December. We'll discuss a couple of instances where it may be valuable for an LLC to opt in early, but in less than a month, it's going to apply anyway. And then obviously after the fact, so everything formed starting January 1 going forward is going to be governed by the new law.
So as far as timing, if you've got, and you'll repeat this, if you've got a well-written operating agreement for an existing LLC, I don't know that there's significant changes under the new versus the old law. There are some clarifications in the new law that at least our operating agreement already addresses. The new law clarifies them by statute. If you're looking at forming an LLC in December, do you want to opt into the new one? Do you want to make sure you get filed by the end of the year and opt out so you can have the old law? In part, that's going to depend on the nature of your clients. If you've got somebody who has many LLCs already and they have an operating agreement that they like and they're about to file a new LLC, they might want to file in December and opt out just so they can make sure all their LLCs are on the same page. But if they do that, I'd have them opt out for all their LLCs. Conversely, if you've got a bunch of folks coming in, this is their first LLC, I don't have a strong preference on whether they are under the new or the old law. In part, you need to talk to them and figure out what their needs are and figure out what's going to work best. But in theory, the new law addresses many holes or gray areas under the old law. So again, in theory, the new law should be just fine.
And then one of the other things as you're approaching the conversation with clients about opting out, opting in, is you're setting the expectation that perhaps opting out isn't a forever decision. As time goes on and we kind of forget what the law is today and get into a world that's governed by the new law for the next decade and practice, it basically the opt-out leaves room for you to have opted in because people just aren't as familiar with the prior law anymore. So setting that expectation that it may just be to slow things down for the time being and not a permanent business decision. So we're going to hop into some of the changes. So one of the big changes that people will notice is currently the law, the statute dictates exactly what can be in the articles of organization. No more, no less. There's no customization. It is exactly what it is. And so the new law allows companies to add additional information into the articles of organization, such as a purpose or a similar details about the company.
And where I've run into this in the past, particularly if you're dealing with an out-of-state lender, often they want language in the articles to give them some control where they can spring in and become a member or have some controls on their creditor LLC. And you could not do that in Wisconsin before. You could do it by separate agreement, but it wasn't baked into the articles. Now that's available. So particularly if you're working with lenders, they may want to look at that, or if you're other folks who may, for whatever reason, want to have some language baked in to the articles that are a public document. Now that's an option that we didn't have before.
And along with changing what is required to be in the articles of organization, the new law no longer requires disclosing the management type in the articles of organization. So if you have an LLC that wants to float between member managed and manager managed management, they're no longer required to change their or amend their articles of organization.
And this is the one area where I could see maybe having an LLC that's being formed now opt in early. And this is kind of tangential to the new law. I prefer manager management for a host of reasons, even if all members are going to be managers. Some of those include knowing who has actual authority to manage the LLC. And as Rob will discuss later, the new LLC law addresses that, one of those issues. So that removes one reason where I might argue for a member for manager management. But I have run into many LLCs where we have, for example, a single member who wants to give 5% ownership to their employee to encourage them to stay on or as a part of a transition plan. Well, if they're member managed, that LLC, by giving 5% to the employee, that employee now has full management rights. Now you can address that by agreement, by operating agreement, side agreement, but it's a lot cleaner. And I often would have the LLC file articles of amendment to become a manager managed LLC, have the founder be named the manager. So the founder retains full management control and the employee can still have ownership without the management rights. With the new law, if the management is not in the articles, you don't have to file the articles of amendment. It's not a big document to file, but it does cost $40 for the state and it is a piece of paperwork. So that is one area where the new law might simplify things, particularly for LLCs that are started as member managed and are getting more sophisticated and want to move to manager managed.
And then just to piggyback off that, that doesn't mean you can't put it in the articles. It's just not required to be in it. And as we'll talk about, the new law has a couple of inconsistencies that will play into selecting whether you're manager managed or not.
Do we want to discuss that now, or are you planning on that later?
I was gonna bring it up.
Okay.
So the next big change that most practitioners are going to notice is that right now, most of us, we think of an operating agreement, we think of this document that the company has. It could be 50 pages, it could be 1 page. But what the new law does is it kind of upends what we think of when we hear operating agreement by changing the definition so that it no longer, I don't know if it's changing how we conceptualize it, where it is no longer a writing. And so the new law creates the concept of a written operating agreement, which when you take it together with the fact that, so here we have the operating agreement is an agreement between the members, whether or not referred to as an operating agreement, and whether oral, implied in a record or in any combination thereof. So with the idea that this broad understanding of what can be the operating agreement, and then creating the idea of a written operating agreement, you could have any number of documents technically be the operating agreement. And that's a different understanding than we would have today, where we probably are thinking of one document.
And as some background under the old law, if you had a written agreement, it was the operating agreement. And if you didn't have a written operating agreement, then you defaulted to the state law rules. And the new rules are incorporating general contract law, which provides that contracts can be formed even if not in writing. Verbal contracts are enforceable. They're trying to incorporate that here. And so the risk is you could have a written operating agreement that says we're 50-50 members. And then if Rob and I have that, but if we don't have an integration clause in that operating agreement, if we don't have something that's saying this operating agreement in this writing is the only thing that's our agreement, and then Rob and I later say, hey, Rob, you know what, you're doing a great job. You have 60% of the profits. If that's oral, that's enforceable. So big picture is, if you have clients, first, they should have a written operating agreement. Second, the written operating agreement should have an integration clause, which again is basically language that says The only agreement among the members relating to the LLC is this written operating agreement, and no change can be made unless it's in writing, signed by, and then whatever, whether it's unanimous or whatever majority you want to set. Otherwise, you run the risk of verbal agreements, email correspondence, just a course of dealing, setting what the agreement is, and that can have evidentiary issues. Hard to prove if you're in litigation.
So in addition then to creating the idea that of the written operating agreement as a specific thing, the new law also identifies things that only a written operating agreement can do. And so among those are alter or eliminate aspects of or restrict remedies with respect to the duty of loyalty. And they can identify specific categories or activities that do not violate the duty of loyalty, the obligation of good faith and fair dealing, or alter the duty of care. So in addition to creating the idea of a written operating agreement, the new law also says that a member doesn't necessarily need to sign the operating agreement to agree to it. And so a member is deemed to agree to the operating agreement by becoming a member.
And this is one of the areas where the new law addresses something that in the past I've tried to address by drafting. Like in part, if you have an operating agreement that normally you'll want to restrict transfers, but that doesn't mean that impermissible transfer doesn't happen. I try to include language to the effect of all the restrictions on this interest. They don't apply just to the member who signs, but they apply to the interest itself. Kind of like with a deed, if you have covenants that run with the land, I try to draft that ran with the interest. Now, I don't know if that's enforceable in Wisconsin, but now with this, that's less of an issue because as long as you are a member, you are deemed to be bound by the operating agreement, even if you haven't signed. And I don't know, does that apply to transfer to unadmitted transferees?
I don't know.
I'm assuming it hasn't, but well, we can look at that.
So the next thing, so management of the LLC. So now since management is no longer required to be disclosed in the articles, all LLCs are presumed to be member managed. And management can only be elected in a written operating agreement. So again, you might be able to put it in the articles that we are manager managed, but the new law says it's very specifically how you elect to be manager managed. And the way is to put it in the written operating agreement.
We've had some back and forth, and this is an area where we think there is some inconsistency in the statute. Rob raised the issue, what if you are a manager managed LLC and don't opt out of the new law and don't have in your operating agreement that you're manager managed? Now, our operating agreement specifies that already, but it's possible you could have that. The question then is, if you don't have a written operating agreement and you're under the new law, does the fact that your articles say you're manager managed, is that suffice to make you manager managed? I think that does, but there's an argument that the statutes are inconsistent. So that is something that I think needs to be reconciled.
And going right into the inconsistency with that is a lot of LLCs try to cut the difference between being manager managed and member managed by creating a managing member. And what the state bar committee has basically said is they're rejecting the idea of managing member. You're either a member managed LLC or you're a manager managed LLC. But if you opt for a managing member, you basically are going to be deemed to have opted into being a manager managed LLC, despite the fact that you didn't opt in to manager management the way the law tells you.
So that raises a corollary issue to what if you have an existing LLC whose articles say it's member managed, you don't opt out of the law, in your operating agreement says you have a managing member. Is that LLC now manager managed?
And the state bar committee is saying yes.
Okay. So those of you who have operating agreements that you have member managed LLCs in their articles, but have a managing member in your operating agreement, they may need some looking at until we get some clarity on the law. And I guess big picture, all operating agreements, this is a time to take a look at, but this is an area, if you use the concept of a managing member, I'd take a close look at those agreements and figure out if you need changes.
There's some changes to the idea of member authority. So the new law gets rid of the concept of apparent authority for members. That just because you happen to be a member, you somehow have authority to bind the LLC.
And this is, under contract law, under entity law, if I hold myself out to a third person as having authority to bind the entity, even though I don't actually have it, I'm not actually a member, a director, an officer, but if I hold myself out to a third party, that third party can rely on my apparent authority unless they have knowledge that I didn't have actual authority. And that apparent authority can bind the LLC. And that's one of the reasons I like manager managed over member managed, because a member can bind an LLC if it's member managed. If, however, I have articles of organization filed that say I'm manager managed, that's a public document. So the third party with a little bit of work can go and find out that the LLC is manager managed, and then should be on notice that they need to have a manager sign the document. That whole issue now has gone away because the whole concept of apparent authority has gone away. Meaning, if I'm a third party, I guess I have a duty of inquiry, maybe not necessarily a duty, but I can't simply rely on somebody signing a piece of paper that they have authority to bind that LLC.
Yep. And so to go along with that, then what an LLC can do now is file statements of authority with DFI to basically say managers have this authority, this specific person has this authority to do specific acts to bind the LLC. And the idea there is to give assurance then to a third party that, yep, Rob is named in this file document, that he can sign bills of sale so he can sell these assets of the LLC, and we can rely on that signature.
Now, you're not required to file these, correct?
No, it's a means of probably counteracting the idea that you can no longer just assume somebody has the authority. And so to give third parties a reasonable expectation that they can rely on that person's signature.
So, for example, a lender, probably it's going to become a new process where they want to see that statement filed with DFI, and they want to get a copy of that. Like, they'll ask for a copy of the articles of organization. Now they're going to ask for a copy of statements of authority. So too with purchase agreements, anything that's a big dollar contract, you may want to ask to see the statement of authority, which means if you're representing LLCs that haven't done that, they may need to file that. And I don't recall what the filing fee is or the process is on that.
I don't know the fee. They're good for 5 years. And in addition to filing a statement of authority, if somebody has been given authority, they can turn around and file a statement denying that authority. So if I'm a member or a manager of an LLC, I can file a statement with DFI that says, yeah, even though this is on file, nope, I don't have that authority. I'm putting out into the universe that I'm not authorized to do what transactions or whatever it might be.
And where this may come up is if you will have an LLC where a member is being bought out, the member may want to file a denial of authority. The LLC may want to require the member to file that. Or alternatively, if you have an employee of an LLC who had a statement of authority saying they were authorized to sign the LLC, the employee, if they leave the LLC, may want to file their own denial that they no longer have authority.
So this is what we were talking about before, where it's in the new law, but it's titled differently. So we missed it on our first go around just because things are just laid out differently. So there's been some changes to the documents that an LLC is required to keep. And so an LLC is no longer required to keep the information about when a member or manager attained their position or ceased to be a member or manager. They're no longer the language about powers of attorney. So in subsection 2 about how somebody would have signed on to one of these documents are required to be kept. LLCs are now required to keep a copy of their file articles of merger, interest exchange, conversion, or domestication. The prior law required tax returns to be kept for 4 years. Now they're only required to be kept for 3.
Now this is state law. So, if the accountant or the tax preparers want to keep it longer, certainly keep it longer. This is what's required by the state of Wisconsin.
And then what I think is probably the biggest change, and is going to be something that requires LLCs to do a little bit more record keeping than they're used to, is the requirement that they need to keep any record made by the LLC of any vote taken pursuant to the operating agreement or Chapter 183. So that requirement is new, and that's going to be a potentially for an LLC a lot more paperwork and record keeping that they're going to have to do.
And arguably, all of these records, both under the new law and the old law, are records that an LLC should keep, but these are now statutorily required. And if you, we've had some discussion is in our prior operating agreement, or if we had a full complex agreement, we often would just mirror the language of the statute in the operating agreement so that the members had in their operating agreement a list of what the statute required them to keep instead of requiring them to go back to the statute. Well, now if those LLCs were formed pre-law, they have the pre-law requirements, but don't opt out, and they are subject to the new law. They have an operating agreement that arguably requires them to keep some things they no longer are required to keep, and doesn't list everything that they are required to keep under the new law. That in itself may not be enough to merit a restatement or an amendment of the operating agreement, but as you go in and look at it, you may want to update the records. And ways of addressing that is to pull it out entirely and just say they will keep what's required to be kept by law, but now they have to go and look at the statute to see what's kept. Or you can update it and just copy this in there. But however you do it, you should explain when you're working with LLC members, you're required by state law to keep certain records, and here's what they are. And these are in addition to anything you might need to keep under for lenders, for tax purposes, et cetera.
So another change is to how people become members. And so current law admits members upon formation as the operating agreement says, or as specified in their records. The new law provides that the organizer will admit each initial member. And so one of the ambiguities that is coming up is if there's going to be multiple original members, the new law provides they're admitted as agreed upon before formation of the company. And so then that says, okay, so what was the agreement to how you guys became a member? So really what it comes down to is you become a member as admitted by the organizers, and the members are not required to be the organizers, and the organizers are not required to be the members. So basically, what it comes down to is whatever the organizers say.
And this sort of now is tracking closer to the Chapter 180 corporation provisions. You can have an incorporator. Attorneys are often the incorporator of a corporation. There's a statement of incorporator, and you can name the new directors. This will be similar now. If the attorney or anyone is the organizer, you can have a statement of organizer saying that, so-and-so is admitted as member. And this is kind of moving the LLCs to more corporate formalities like corporations. That may be a good thing. For smaller LLCs, it may be more paperwork that they're not expecting.
And then finally, after the formation of an LLC, their members are admitted as the operating agreement says, upon unanimous consent of the members, through a merger of the LLC and things like that. And so there's a list in the statute. So another change is the idea that an LLC could be used for a nonprofit entity. And the new law provides that members may be admitted without requiring a transferable interest and without making a contribution.
And this is arguably a change. It wasn't clear in Wisconsin whether you could have a non-economic interest. There was nothing authorizing it, but neither was there anything prohibiting it. Now the statute specifically allows having a non-economic interest. And we can use it for nonprofits or for a lender, often bringing ownership where, for example, the lender by agreement is not a member unless the LLC files for bankruptcy. Then the lender comes in and has a controlling interest as far as guiding the LLC to address financial concerns.
So going forward, a contribution can consist of money or property transferred transferred to, services performed for, or another benefit provided to the limited liability company. And so on as the statute provides. And the drafters indicated that the idea of other benefit used in this section was supposed to kind of mirror benefit that was used for corporations. And therefore it should be broadly construed to include basically services rendered, any other benefit obtained by the corporation, including the contribution of its shares to a charitable organization, or any the Model Business Corporation Act commentary, I guess, has a very broad understanding of how benefit should be construed. And so the idea was the new LLC law should mirror that understanding, although not using the same word.
Yeah, and it really just clarifies and gives greater flexibility to how a person can become a member. And you don't have to prove consideration. It's not as hard to prove consideration.
Yeah.
But there is a hidden tax trap here in that if you contribute services or something to an LLC other than money, it may be deemed, if the IRS looks at it, that you have actually performed the services for money and contributed it to, and you have phantom income. Services is the obvious, is the well-known one. So if you have somebody who comes in and contributes $100 for 50% of the LLC, Rob puts $100 in, and I say, I'll manage the LLC for 50%, but I won't put any money in. If that could be viewed as my services being $100, I have $100 of taxable services that I have to pay income tax on. You can get around that with a profits interest, but that goes beyond the new law. But just be aware that it's easier now to become a member of an LLC without having to put in something like cash.
And the new law also removes the requirement that the obligation for additional contributions need to be in writing. And basically what the drafters are saying is this becomes something to be resolved with the rules of evidence. And that basically you guys can decide amongst yourselves and deal with it of whether or not there was an obligation to make an additional contribution. Except that the obligation for an additional contribution can only be compromised by the unanimous member consent or a written operating agreement.
But now back to that, I'm sure we'd all advise that if there's an agreement among the members, it should be in writing. So you can kind of, if you're worried about this, if you have an operating agreement that says the only way you can make an additional contribution is as provided in this operating agreement, the only way you can be required to make an additional contribution is in this operating agreement. And this written operating agreement is the only agreement among the members, that I think you get around the risk of having a verbal agreement to make an additional contribution. A defense.
So then there's some changes. So to the distribution, so interim distributions can only be made at the election of the LLC. And then absent a written operating agreement, the default rule is that the distributions would be proportional based on contributions. And the new law specifically carves out LLCs that are taxed as partnerships and sets the default to proportionality based on capital accounts.
And this is important to note, that distributions, whether on contributions or capital accounts, may not be what the members anticipated, particularly if the members came in at different times and contributed at different amounts. If Rob and I come into the LLC at the same time, we each put $100 in, we get 50-50 distributions. But if Rob formed the LLC, he put $100 in, it goes well. And a year later, I come in, I give him $500 for 50% interest because the LLC is now worth $1,000. He's only put in 100 still. I put in 500. If we don't change that in the operating agreement, I get $5 to every $1 he gets distributed, even though we have 50% ownership. So you definitely want to make sure you address that in your operating agreement.
That goes along with the changes then to voting power. So the default continues to be the allocation of votes according to contributions, which may or may not be the intention of LLCs who have members come in at different times.
And this was the law, but the exception is new.
Yep. And so again, and the drafters talk about this as meeting businesses kind of how they're practicing and where they're at is the change to LLCs, taxes, partnerships now are going to default to voting based on capital accounts. So the next changes come to charging orders. So the new law distinguishes between single and multi-member LLCs in foreclosing a charging order. And so Wisconsin didn't have anything on this, but historically courts had drawn distinctions between multi-member and single-member LLCs. And
yeah, let me jump in. So a charging order is like a garnishment. The whole thought is in an LLC, historically it was more closely held and you would pick your partner. In contrast, in a corporation, it's more of a financial transaction. You're investing in something. So for a corporation, if I own a stock in a corporation and I owe money, my debtor, my creditor can force me to sell my stock, and now or can foreclose on the stock, and the creditor takes my stock. With an LLC, the default was a charging order, meaning you can't take my membership interest, but you can get an order charging the LLC to anything that's going to be distributed to me instead gets paid to the creditor, like a garnishment. And the thought on that was, if Rob and I form an LLC, Rob is counting on me being his partner, and Rob doesn't want the bank, the lender, to become his partner. Now, there's obviously tension between that and the desires of creditors. So part of the argument is are charging orders the exclusive remedy, or can foreclosures be allowed? Wisconsin did not say the charging order in prior law was the exclusive remedy. So I would argue that the change is more of a clarification here than a change in the law. The other issue, though, is if it's a single member LLC, the pick your partner principle doesn't apply. If I'm the only member, why should the creditor be limited to only getting a distribution from my LLC? In Colorado, Florida had case law that said basically, yes, a single member LLC could be foreclosed upon and the member have to sell their interest or give it to the creditor. Wisconsin didn't have any of this case law, didn't have that charging order was the exclusive remedy. The new law basically kind of digests what's happened in other jurisdictions and treats that a multi-member LLC, the primary remedy is a charging order, but that doesn't apply to a single member LLC. But there is a nuance that it does allow a foreclosure even in a multi-member LLC, which is where I'm going to turn it over to Rob.
Yep, and that's where the pick your partner comes back in. And so basically in a multi-member LLC, the foreclosure of the transferable interest doesn't permit that party then to become a member. So it keeps that distinction up to that point.
So they're an unadmitted S&E.
Yep.
But so they can have ownership, economic interest, but not membership rights.
That is my understanding.
But still the default is the charging order is the first remedy. A creditor can only garnish, that's not the right word, but it's commonly, they can get an order to get the distributions. But if the distributions aren't enough to reasonably pay off the creditor in a reasonable time, then the creditor can proceed to the foreclosure, force a sale. But again, whoever buys it still is not a member. They just have economic rights, no management rights.
So the new law creates the concept of wrongful dissociation. And that occurs in a limited number of circumstances. The member breached the terms of the written operating agreement, or it occurs before the winding up or dissolving of the LLC is complete. And that comes in that has two components. So the member is either removed by judicial order, or the member becomes a debtor in bankruptcy, or makes assignments or other debt collection, or accedes to other debt collection practices. And so basically you can get a dissociation by judicial order if the members engage in conduct that is or will materially be adverse, to have an adverse effect on the company, or the member willfully or persistently violates the operating agreement or the member's obligations.
And we historically tried to address this concept in the operating agreement itself, but now there's new statutory provisions that in our going forward drafting, we will incorporate.
So the new law preserves most of the existing law when it comes to acts that can cause dissolution and the process of dissolving. Again, here for partnerships, the default is kind of changed. So LLCs, tax partnerships default to dissolution distributions proportional to the capital accounts instead of back to the members based on contributions.
And I should probably take a step back. So LLCs, part of the beauty of LLCs is they have flexibility in how they are treated for tax purposes. A multi-member LLC by default is going to be taxed as a partnership, but it can elect to be taxed as a C corporation or an S corporation. Likewise, a single member LLC will be taxed as a disregarded entity, and single member in Wisconsin also includes an LLC owned by husband and wife as marital property. It's still treated as one owner. Their default is it's a sole proprietorship. Taxes flow through to the owner's personal tax return, but they too can be elected to be taxed as a C corp or an S corp. And we'll come up on this. The taxation, in theory, shouldn't have been an issue as far as state law of LLCs. The Marks v. Morris case puts some doubt on that. The statute has tried to address Marks v. Morris, but this is one case where they expressly bring in a partnership tax into consideration, but this is for economic purposes, not for fiduciary duty or other purposes.
So members can maintain a legal action to enforce their rights or interests of as a member, whether they arise from the operating agreement or such right arises independently of the membership relationship.
And this is where Marks v. Morris really did disrupt prior law by looking at the analysis was, could a member file a lawsuit on behalf of the LLC? And in this case, the majority opinion looked closely that the LLC was taxed as a partnership and found because of that, then it was reasonable for the member to be able to bring a lawsuit on behalf of the LLC. The dissent in Marks v. Morris, and I believe this was a 2018 case, the dissent rightly pointed out that that raised the question of if this were an LLC taxed as a corporation, would the result be the same? Arguably, it wouldn't have been based on the analysis. But now the law here, the new law has basically overridden Marks v. Morris by providing the new rules that Rob will continue with.
Yep. And so for a member to bring an action under this, the member needs to plead and prove that an actual or threatened injury is not solely the result of an injury suffered or threatened to be suffered by the limited liability company. So it's got to be separate from that. And then it mirrors corporation law in that the new law allows a special litigation committee on the motion of the LLC to determine if the suit is in the LLC's best interest, which again is similar to the corporation law. So the new law states outright that the law of the LLC's home jurisdiction is what's going to govern its internal affairs. However, registration with DFI is still required.
And again, this is for an LLC formed in a state other than Wisconsin.
Yep. So it's still required for doing business in the state. The failure for an LLC to register with DFI is going to result in penalties to the company. But not registering isn't required and won't have negative consequence to the LLC with regards to their right to own property or defend an action in Wisconsin. I have an open question about whether it allows them to bring a suit in Wisconsin if they don't register, but if you don't, it's not going to affect your ability to have been bound by a contract, own real estate, or defend an action.
Now, certain states specifically say that if you're not registered in the state, you cannot initiate a lawsuit. You can still defend a lawsuit, you can't initiate that. I'd looked at this before. Wisconsin wasn't clear on that. It wasn't in the statute, and it sounds like it's not in the new statute either. I still, if you have a foreign LLC that wants to sue somebody in Wisconsin, I would certainly recommend you make sure that if they're transacting business in Wisconsin, they get brought current. We've also had this come up several times where we've had companies whose owners have maybe moved to Wisconsin, they'd formed in another state, and they just moved their headquarters up here and didn't do anything. Well, now they're physically in Wisconsin, they're probably transacting business in Wisconsin, they should be registered. If you come across that, you need to analyze when did they start doing business, and you need to figure out how best to get them brought current.
And so this is going to bring in some of the changes we talked about to some of the other business entities. So the new law explicitly authorizes cross-species conversions of an LLC into any more types of foreign or domestic entities. And the way that the statute defines the entities basically is a conversion to anything that's not an individual. And so instead of being this simple list of an LLC can convert to these specific things, it's kind of opened the floodgates. And as long as you're not converting to another human being, that type of conversion is allowed.
So this allows, some jurisdictions have the concept of business trusts. You could have a Wisconsin LLC convert into another state's business trust, or vice versa.
Yep. And so the new law has some protections for members who might not consent to a conversion because of the potential for a much more liability. So hypothetically, a member of an LLC could end up as a member of a general partnership without having elected to do so. And so the new law provides some protection for that person if they didn't sign on to either that conversion or a written operating agreement that said, hey, I will allow this type of conversion that could put more liability on me with less than unanimous consent.
And it would be odd for an LLC to convert to a general partnership, but if that were to happen, this law protects the unexpected liability.
And then there's also just some vocabulary changes. So the new law defines domestication and conversion differently than it currently does. Domestication means means an LLC which is a non-US entity also being governed by Chapter 183.
And this is where Wisconsin is really kind of diverging from commonly other states. Domestication in general means just moving from one jurisdiction to another as your home jurisdiction. Here, Wisconsin is domestication means you have dual existence in a foreign country, but also if you're operating in Wisconsin, then Wisconsin is your home jurisdiction, even though you still have a foreign countries organization.
And then conversion is just the change of entity type, whether governed by Wisconsin law or that of another state. So we've thrown a lot at you. I think the big takeaway, and hopefully what you picked up a little bit, is we're all still working through what the new law means for LLCs. But LLCs with a well-written operating agreement may not see that many practical changes. However, LLCs and their advisors may find it more conservative to opt out of the new law while we wait and see what happens. And I think that's kind of the big takeaway from this is if you're a multi-member LLC and you're not exactly sure what everything means for you, slow it down and just opt out while you figure it out.
No, I agree. Now, again, and on the final point though, if your LLC does not have an operating agreement or your members don't know what's in them, I mean, they should really consider updating and reviewing those agreements. I mean, particularly LLCs without operating agreements, before they could rely on whatever the state statutes were, that's our default. Now it's, well, whatever we can show in the course of dealing or in emails or in conversation. I mean, that's kind of a Wild West. So hopefully, you know, our clients have a well-written operating agreement. Even then, I would recommend, as Rob said, to give the time to kind of see what's going to happen. Elect out. It's an easy form, but you need to get it done before year end. And with Wisconsin Department of Financial Institutions schedule, really, you want to probably get it done by December 20th, around then. So you've got not a lot of time to do that. You can opt out. There's no cost to opt out. You can opt in later. There's no cost to opt in. I will say, though, that opting out and forgetting is not the end of it, because as we go further down the line, memories fade. And as courts develop law under the new law, you know, it's going to be a lot easier to just look at the new law and say, even though you're under the old law, we're going to look at under the new law, we find this way, and then we find reasons to say we would have found the same way under the new or old law, and so here we are, which is kind of just saying the new law is what people are going to be used to, and that's where things are going to gravitate to.
And then just one last plug to piggyback off that, on the website, we have an article, watch out, here the new LLC law comes. In it, it has the applicability portion of this conversation outlined, but then it also embedded in it, it has the opt-out form for clients.
Links to the form, yes.
So if you're that way, you can just easily forward that if you're thinking of someone or yourself, and just use that form as a resource, or that article as a resource to look at that decision and then to find the form. So with that, does anyone have any questions?
So we did see there was one question in the chat from Attorney Starkweather, roughly 15 minutes in, asking, is there also a risk that Wisconsin does not require a separate consideration to amend an executory contract?
I think that, John, that goes beyond the scope of what we're looking at, but if we're talking about the becoming a member, what is consideration is greatly expanded. I don't know if that addressed your question, John. Feel free to unmute and chime in.
Yeah, I'm mostly getting at the risk that you enter into an operating agreement and then there are subsequent agreements between the members that are not reduced to writing. So it's kind of the Wild West thing that you talked about. You could spend all this time drafting an operating agreement, but then if your clients go off menu and start making separate deals, and they're not amending the operating agreement, then we've got this awful situation where even if the operating agreement says it can't be amended except in writing, it can still be amended. And if you try to argue there was no consideration for the amendment, you lose because you don't need consideration. So
yeah, it comes down to contract principles. So I would argue it depends. Yeah, and I could argue either way, and it depends on the facts, right? But if I have an operating agreement that says it can only be amended in writing, signed by all the parties, I guess I'd argue that side agreements don't count unless they're in writing, signed by all the parties. And you could try to address that by saying in your operating agreement that writing also has to expressly say it's an amendment. And so I think if you get in the weeds, it can become very fact specific. But to give the most protection, have the integration clause that says this agreement can only be amended in a writing, signed by all parties, that says it's an amendment to this agreement. It's not bulletproof, but I think it gets you most of the way there.
All right, anybody else?
And feel free to just unmute and chime in if you have a question. All right, well, Rob and I are available offline if you have any follow-up. If you want a copy of the PowerPoint, I don't know if it was already circulated, but we can certainly get that posted. With that, anything else? If not, thank you for attending.